case briefs, and so much more. LSData's got what you're looking for.
In Ogden, Utah, tenant Linda Jobe discovered various defects disrupting the habitation of her newly rented house, including a recurring sewage problem causing loss of hot water. Despite repeated notification to her landlord, Clyde Wade, who attended to the issue by pumping out the sewage each time, the problem persisted. In November 1988, frustrated with the unending issue, Jobe informed Wade that she intended to withhold rent until the issue was permanently resolved, a solution that never materialized. An inspection by the Ogden City Inspection Division further revealed serious code violations, prompting Jobe to finally move out. The unresolved issue prompted a legal exchange. Wade sued Jobe for the unpaid rent, and in response, Jobe lodged a counterclaim under the Utah Consumer Sales Practices Act, UCSPA. She argued for compensation due to the uninhabitable condition of Wade's property. In a surprising verdict, the court ruled in Wade's favor, dismissing Jobe's counterclaims and denying her any offsets. The ruling in Wade v. Jobe was seen as a test of whether tenants could seek compensation under the framework of the implied warranty of habitability, and if the UCSPA could be applied to residential rental transactions. A poignant appeal followed, causing the Utah Supreme Court to review and overturn the initial decision of the lower court. The Supreme Court referred the case back to trial based on the potential breach of the warranty of habitability by Clyde Wade. The ruling underscored that if the landlord was found culpable, Jobe could seek rent abatement. However, if the court rules in favor of Wade and no breach is found, Jobe would be liable for the past due rent. In addition, the court dismissed Jobe's counterclaim under the UCSPA. Utah Supreme Court Justice Zimmerman concurred with this decision.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of climb.